Welcome to the latest episode of Dan Talks. Today our conversation will again be turning towards patents, more specifically the unjustified threats provision in section 128 of the Patents Act. You'll remember from our last podcast that a patent is a type of IP right granted to new inventions, which provides the owner of the invention the exclusive right to exploit it commercially for the life of the patent. As patents are not automatically granted, people who have taken the time and expense of acquiring a patent want to be able to protect it from potential infringers. As the cost of litigation can be expensive, patent holders often take steps before a lawsuit to protect their interests. This includes threatening legal action against people who they feel may be in breach of their patent. It is important that patent holders are cautious when threatening a potential infringer, as in some circumstances this could result in a threatened party claiming an unjustified threat was made against them. The purpose of the unjustified threats provision is to prevent patentees throwing their weight around by threatening litigation in circumstances where the threat is not justified. Traders should be free to conduct their business without the threat of litigation hanging over their heads, so the unjustified threats provision acts as a protection for them. An example where this provision is relevant is as follows. Mariah holds a valid patent and believes that Jennifer may be infringing on her rights, so corresponds and threatens legal action to stop her from her alleged infringement. If Jennifer is not in breach of anything and feels as though these threats are not warranted, she may seek relief for these unjustified threats under Section 128 of the Patents Act. Jennifer, under this section, can apply to the court for a declaration that the threats are unjustifiable, an injunction against the continuance of the threats, or the recovery of any damages sustained by the applicant as a result of the threats. So what are the elements for someone like Jennifer to establish that the unjustified threats provision applies? The first element is delivery. This element looks at the way that the threats can be delivered or communicated by the patentee to the alleged party in breach. In Section 128, it refers to the threats being communicated by circulars, advertisements, or otherwise. However, the courts have interpreted this more broadly to include threats communicated orally, in letters or writing, by advertisements, or on the packaging of the product itself. For the communication to be actionable, it must constitute a threat. This leads us to the second element, that the person was threatened. The current test of what constitutes a threat stems from the case of U&I Global Trading and Tasman Warrajay. In this case, Justice Cooper said a threat would be present if the language used would convey to any reasonable person that the author intended to bring proceedings for infringement against the person said to be threatened. It is important to note that under Section 131 of the PA, the mere notification of the existence of a patent does not constitute a threat of proceedings. The third element is that the threat must be unjustified. A threat will be unjustified if the patent owner cannot make out an actual infringement of their rights. We'll take a look now at the case of Mitzi Family Holdings and Morinelli No. 3. In this case, Mr. Mitzi and Mr. Morinelli together developed a cane billet planter, but Mitzi applied for a patent first and claimed Morinelli was in breach of it. Morinelli claimed unjustified threats as a result of an article and notice printed in Cane Growers magazine, which warned sugar farmers of the danger of copying patent inventions. It was found that although not directly targeted at Morinelli, the article and the notice did constitute a threat. Thus, because there was no breach of the patent by Morinelli, the threat was unjustified. Under the PA Section 129, if the patent owner satisfies to the court that the acts of the alleged infringer did in fact infringe the rights of the patentee, then the threat will be justified.